In March of 2010, the Jamaica Deposit Insurance Corporation, JDIC, staged the first Caribbean Bank Insolvency Conference at the Rose Hall Resort and Spa in Montego Bay. Over 20 experts from countries across the Caribbean, Canada, the United States and United Kingdom spoke on issues relevant to the global financial crisis, international initiatives towards best practices and resolutions for bank insolvency.
Today we'll bring you highlights of the presentations given by Litigation Partner at Appleby in the Cayman Islands, Andrew Bolton, an advisor on regulatory policy and cooperation at the Financial Stability Board in Switzerland, Dr. Eva Hupkes. Dr. Hupkes addressed the case for Lex Specialist for bank insolvency, and Andrew Bolton provided an overview of cross-border insolvency under Cayman Islands law. Andrew Bolton is a litigation partner with Appleby in the Cayman Islands. He is responsible for Appleby's litigation and insolvency practice. Mr. Bolton's proficiency is widely sought after as he specializes in contentious insolvency matters and commercial litigation including fraud, asset recovery, and professional negligence.
The insolvency legislation as it now stands really comprises these four elements. All of them have some element of cross-border application to them, and it's those aspects of the legislation that I will be focusing on. Clearly they have a much wider application. The four pieces of legislation are the Companies Law, now in its 2009 revision. The key parts there are Part 5 and what was Part 16 when enacted but has now become Part 17 as a result of the insertion of another section, another part dealing with mergers, though unfortunately in the published version of the legislation it's still referred to as Part 16, so we have two Part 16s, but I will refer to it as Part 17. We have the Companies Winding Up Rules 2008, which are our own insolvency rules, the Foreign Bankruptcy Proceedings International Cooperation Rules 2008, and the Insolvency Practitioners Regulations. I'll deal briefly with each of those, and in particular the cross-border elements of each one. First of all, the Companies Law, Part 5. Most of this doesn't really have much to do with the cross-border side of things. It deals with all the normal aspects of corporate insolvency. So to provide for the procedural implementation of of Part 5 in general, the whole insolvency regime, we have the Companies Winding Up Rules 2008. Now mainly they deal with things like how you file your petition, the appointment of liquidation committees, the role of the liquidator, filing proofs of debt and all that sort of thing, not the kind of thing that I've been asked to talk about, which is the cross-border elements. They do, however, provide one quite interesting new provision, which has a cross-border element to it, which is the question of international protocols. But what's interesting about this new provision in the Winding Up Rules is that it actually imposes on official liquidators of Cayman Islands companies the duty to consider entering into a protocol where there are parallel proceedings in any other jurisdiction, or where assets overseas are subject to foreign bankruptcy or receivership proceedings. So they have now a duty to actually consider entering into a protocol. Obviously they can't necessarily achieve it, but they have to investigate it and see whether it's possible. So just as we have the Winding Up Rules to deal with Part 5 of the law itself, we have some special rules to deal with Part 17. They are the Foreign Bankruptcy Proceedings International Cooperation Rules. They're really pretty straightforward. There are only three operative rules. One lays down the procedure that has to be followed when you're applying for an order recognising a foreign representative. Basically what you have to put in the application, what you have to put in the affidavit in support. One of the key things is that there needs to be evidence before the Cayman Islands court of the law that operates in the foreign country and the basis on which the foreign representative is alleged to be entitled to act in the name of the debtor. What his powers and duties are under the law of his place of appointment. One of the other rules makes very similar provision in relation to other types of application, things like applications for injunctions, stay of enforcement, examination of individuals, or delivery up of property. And finally, there's a requirement that any Cayman Islands company and any foreign company registered in the Cayman Islands that becomes the subject of bankruptcy proceedings anywhere else has to give notice of that fact to the registrar in the Cayman Islands and advertise it locally. That's a new obligation. The final piece of the legislative framework in the Cayman Islands is the Insolvency Practitioners Regulations 2008. However, on the question of compliance with the procedural rules, it always has been, and I think is now even more so, pretty rigid when it comes to strict compliance with all the things that one has to do. That's partly because the new companies winding up rules that I mentioned do not contain the sort of provision that's often found in court procedural rules that says that if there's a minor departure from the rules and nobody's prejudiced by it, the court can overlook it. We do have a new specialist financial services division of the Grand Court, which will deal with almost all insolvency matters, and that will be a significant help because we will have a number of judges who have very great detailed experience of insolvency and cross-border insolvency in particular, focusing on that type of work. It has some specific rules to make the procedure more suitable for that kind of case as well.
Dr. Eva Hupkes is the advisor on regulatory policy and cooperation at the Financial Stability Board in Switzerland, a position she has held since 2009. She is also co-chair of the Basel Committee Working Group on Cross-Border Banking Resolution and was instrumental in the development of key regulations, such as Basel II. Dr. Hupkes is also a lecturer in international financial regulation at the University of Zurich and Goethe University, Frankfurt.
In my remarks today, I shall try to respond to three questions. Why do we need a special resolution regime for banks that differs somewhat from general corporate insolvency laws? What essential features should such a regime have? And what are the challenges and how can they best be addressed? Banks provide payment and other services that are fundamental to the functioning of an economy, and they constitute a means for the transmission of monetary policy, and this makes them special, but of course not unique. It is the nature of banks' activities that is special because it makes them very fragile. They have higher leverage than non-financials, and they have a larger maturity mismatch. They fund longer-term assets with shorter-term liabilities, and if a significant portion of their funding is withdrawn at very short notice, which may be due to a sudden loss of confidence, whether substantiated or not, banks can fail within a space of days. Let me now turn to my second question. Why should we not just rely on the general corporate insolvency law to resolve failing banks? Well, bankruptcy law only applies when an institution is already insolvent or on the verge of insolvency and drained of all realizable economic value. For a bank, this is too late. Its capacity to perform essential functions, payment and clearing, credit extension, acting as a repository, public saving, all these functions will then have been compromised. But even if the tools of insolvency law were applied earlier, they would not be appropriate. Their application would result in a general suspension of the bank's payments, and a stay on payments is a stay on a bank's critical function. And this is what needs to be avoided or mitigated given the effects it has on the financial system and on economic activity. So, a special regime, what are its essential features? Well, let me stress three characteristics that distinguish a viable and appropriate regime for bank resolution from one that is provided under general corporate insolvency law. The first is early intervention and resolution, then flexibility and speed, and the adequate protection of depositors. Another problem with standard insolvency procedures is that it may take months or even years for creditors to be compensated. For this reason, a well-designed and adequately funded deposit protection regime is an essential component of an effective bank resolution framework. As I said at the outset, there are significant challenges in designing effective bank resolution frameworks, in particular with respect to those globally active financial firms, which are a special focus of the Basel Committee and the FSB. So let me mention those that actually start with a C, and that is complexity, connectedness, costs of resolution, and cross-border conflicts. And I'll elaborate a bit on each of those 4 points. But why are these structures so complex? Well, the usual suspects, of course, are tax, corporate law, regulatory arbitrage, ratings management, secrecy provision. The G20 called for them to be put in place for all major firms, so for all major globally active financial institutions. So-called crisis management groups have been put in place, and these groups build on supervisory colleges, but they also not only include the representatives of supervisory authorities from key home and host jurisdiction, they also include representatives of the central bank's resolution authorities, in some cases treasuries from key home and host jurisdiction. And their role is to promote contingency, cross-border contingency planning discussions, and the elaboration of so-called recovery and resolution plans. This brings me to the next challenge, that is connectedness. Connectedness can result in one failure causing other failures. Wholesale funding, interbank funding, and the use of increasingly complex layers of financial intermediation are examples. These complex layers of financial intermediation lead to opacity and uncertainty about the soundness of counterparties and customers. Securitization regime. Well, now let me turn to one of the most sensitive issues, and that is the question, basically, who pays and who bears the losses. And there is broad agreement on a number of objectives. That is, first, that losses should be allocated across relevant equity and creditor classes, that losses should not be borne by the government and taxpayers, that losses should be allocated in a predictable manner, and here I defer to Philip Wood, who is an expert on priorities and creditor protections. Markets dislike uncertainty. And fourth, the allocation of losses needs to be sufficient diffuse so that it does not trigger further failures. And one thing is certain, that in the future, national authorities will need to focus more on the adequacy and effectiveness of resolution regimes and depositor protection arrangements, both in home and host jurisdiction. So when they decide in what form and under what conditions firms can operate in their jurisdiction, they may do so on the basis of their assessment of whether the firm can be effectively managed, supervised, and resolved in a crisis. Most importantly, and specifically, the respective responsibilities of home and host authorities for supervision, the provision of liquidity, and for resolution must be clear and properly aligned. The task is not easy. There are huge vested interests. In the end, jurisdictions will need to make a choice. If they are prepared to make clear commitments that will permit effective resolution of global banks, it will be possible to reap the efficiency benefits of financial integration. Otherwise, we will be condemned to repeat the past.
In our next episode, we hear from attorney at law from the firm Allen & Overy in London, Philip Wood, and acting director of the Financial Services Commission in the British Virgin Islands, David Abednego.